of the executive, the judiciary makes its own rules.
Yes,
right? Only those rules made by the executive or other organs which are in conflict with the Constitution can be looked at by us, and if we find they conflict with the Constitution, they have to be struck down. So those three firewalls have been intentionally, deliberately created by the Constitution, and the interest of every citizen of the state is that they remain intact.
Absolutely, my lord.
Number two, substantive right है right of appeal. My question is, how can a procedural law, even if it is not ultra vires, provide such an appeal?
It can't. It can't.
Now, Mr. Uzair, if I understand you correctly, and I just want to close this point here, that you're saying that for the purposes of substantive right to appeal, entry 55, we have to, the law has to pass the test of entry 55, and entry 55, then you also say that there are two problems with it which are still unclear and unanswered. One is that there has to be express provision. Under the law is not clear, and it is not clear how jurisdiction is being vested in the Supreme Court through other statutes. So while we rely on 55 for this, 55 itself is shrouded in a bit of a mystery, and there are unanswered questions.
Yes.
Is that right?
Yes.
Thank you.
Mr. Vendari, just one minute. Now, assuming that this power to make law under 191 is an enabling power, the subject matter is the practice and procedure of the court. So, could it be said that the power of the court, the rule-making power, in respect of this subject matter, and the power, if this is an enabling power of Parliament to make a law, are coterminous, meaning they extend over exactly the same area?
My lord, I would say no, because then once Parliament covers everything, then there is nothing.
I'm not saying. What I'm saying is, whatever is the subject matter of the practice and procedure of the court has the power to make rules in that regard.
My lord.
If law as used in 191 is an enabling power, it operates on the same subject matter, and the area therefore is the same.
If it is used as an enabling provision,
Yes, yes.
then yes.
But then if that is so, you have just told us, and quite rightly so, that in exercise of rule-making power, the Supreme Court cannot give a right of appeal.
Can't.
So therefore, if the two powers are coterminous in respect of the subject matter, my question to you is, how can, if it is an enabling power, how can Parliament use Article 191, because that is what is referred to in the
Yes.
preamble, how can it use that power to confer a, how is that possible?
It can't. It can't be.
So I agree with the comment made by my little brother, but and just adding to that, to the extent of practice and procedure, if we were to take 191 to be an enabling power, then to the extent of practice and procedure, the law is correct. As far as the substantive provision of appeal is concerned, we'll have to look the other way, and then we'll have to look at 55, which, as I had earlier said, is already full of confusion and not very clear. So that's that. But as far as the law on practice and procedure is concerned, if we were to imagine that 191 is an enabling provision, then the law passes the test, the committee and all the other provisions, except the substantive part of appeal, which is still unanswered, and we wait for the others to
My lord, even then, that's why I added a caveat at the outset that even if it is an enabling provision and enables Parliament to enact a statute for rules and procedure on the basis of 191 itself, it will still be subject to some all overarching constitutional principles. Now, one constitution,
that's fine.
my lord, allow me to finish this. One overarching constitutional principle, which in my humble opinion, and that's what I've submitted, has acquired the status of a constitutional convention, is the power of the Chief Justice to form benches. Now, I'm not for a moment saying that that should not be revisited. I'm not for a moment saying that. I'm saying that since that has achieved the status of a constitutional convention, that constitutional convention is being continued by virtue of the provisions of Order 11 of the Supreme Court rules. Therefore, The Parliament can't undo that, as held by Baz Mohammad Kakar. Your lordships will have to do that in exercise of rule framing power.
So आपका जो point है ना, suppose if we were to take 191 to be an enabling power, then we look at the law, and we look at the law, then it has to pass the muster of fundamental rights and all. And yes, I would agree with my learned brother who had referred to my earlier order relating to the committee deciding the thing, which is I'm very clear on that issue. There could be either that has provision, could be, speaking for myself, read down, or we're not sure whether at all they judicially decide this question or administratively decide this question. One would imagine because it's a committee, it is more of an administrative thing.
Yes.
That's a snag which needs to be rectified, but that's that.
Yes, yes. So,
Can I just place a conundrum before you, and if you can respond to it?
another one, my lord.
This is the first one. This is the first one. Suppose I, in the person of the Chief Justice, become very unreasonable. All my colleagues ask me to call a full court meeting to amend certain rule which requires amendment, okay, or some other issue. I say, no, I will not do it. So there is, nobody can do anything about it, pehli baat. So when we talk about, there are two arguments. One is trichotomy of powers. Then within a particular constitutional body like the Supreme Court, yes, I can go along with the first one, but then are you also propagating the omnipotency to the Chief Justice, or as used to be criticized, the Lord Chancellor of England, and the equity varies with the Chancellor's foot? So suppose I become unreasonable, tough luck to all of you, to everyone in Pakistan, tough luck. Right?
No.
How will you resolve this?
My lord.
Parliament has said, well, you may not like it, Mr. Chief Justice, but we have made an attempt to resolve it, because you are never going to do it. You are never going to do it. And you are, by your conduct, have shown you are never going to do it. So you can say, no, we must persist on omnipotency to the Chief Justice, the person of the Chief Justice, and he can do no wrong. And let him do. Is it democratic? Is it just? Is it forget the Constitution of Pakistan for the time being. I'm talking now of greater concepts like justice and fairness. Does it meet? We talk about Islam, but surprisingly enough, not one person has mentioned Islam here. Does Islam even permit this? Such a powerful person, unaccountable, totally. And someone legislates, the only thing I find fault with is, how dare you legislate? I can do so, but I will not do so. Now tough luck to you, Mr. Bhandari and everybody else. Do whatever you want to. So it suits me. Like I said, my colleagues are much too kind to articulate something, but I think it needs to be articulated and said. And please respond to it. How will you check my unreasonable conduct?
If I could add to that, not only the Chief Justice's conduct, but suppose if the full court sits down and makes a rule that we'll hear cases twice a week only, we'll only work till 10 o'clock, and so be it. And firewall, good luck to your firewalls. And we're firewalled, we're just very covered. We could just hear cases only twice a day and twice a week, and just till 11 o'clock or whatever. And we could have a vacation for 6 months, or things like this. So we're firewalled, nobody can touch us, so we can just run the court the way we want, in any manner that we want. And the Parliament, which represents the people, cannot come up and say, sir, what are you guys doing? Come on, have a heart.
But can I turn the example on its head? Can the Parliament say that your lordships will work 24/7, 365?
जवाब दे दें हम हमारे conundrum का फिर आप confuse हो जाएंगे
Before you
भंडारी साहब.
reply to these questions,
Sir.
let me ask you a question. In the Supreme Court in Pakistan, do we have lifetime appointments or do we have a retirement age?
Age of superannuation, yes.
So the composition of the court keeps changing.
So basically, you wait till my retirement.
If you
Not at all.
You can't touch me till I retire.
Mr. Bhandari, the late Donald Rumsfeld said something very helpful. He said, we'll jump off that bridge when we come to it. We will deal with such autocracy when your lordship turns it.
Precisely, we'll deal with such a law when it sort of takes away our power. If it enhances our power and it makes more transparency, we will not touch it. We'll touch it when it takes away our powers or makes things more difficult for us.
My lord,
Mr.
Mr.
Bhandari.
Bhandari, do we also have in this, do we also have,
oh, sorry, sir.
Mr. Bhandari,
do we also have something?
may I ask a
something
question,
called,
please?
Just a minute, madam. Do we also have something called the Supreme Judicial Council? So if we have, with all due respect, and these are hypothetical examples being given, so my question is also hypothetical.
And how effective has been the Supreme Judicial Council?
I don't think if I don't call a full court meeting,
is something
the matter
that,
can be taken to the Supreme Judicial Council.
is
I don't
something
think you can
I
stretch
may
misconduct
please-
to that extent.
Let me,
My lord, the moment your lordship thinks
Let
of
me
taking that
ask a
attitude,
question,
My lord,
please.
everyone here will
I think we-
let me
He's
ask a
been very
question.
quiet.
मैंने डिस्टर्ब कर देना सबको, मुझे भी इजाजत दी जाए, बस I'm sitting quiet. Sir, it says that the Act 2023, it says that whereas the Article 199 of the 191 of the Constitution provides that subject to the Constitution and law, which law the Act is referring to, which law the Constitution is pointing finger to? Was there any law at that time?
No act.
Because the rules were framed, notified in 1980, and the law has been made in 2023. So
That's
which
what
law they were referring to?
They were not at that time.
Because I think the constitutional amendment has been made by unconstitutional means.
quite,
शक्ल बदल गई है constitution की.
quite possible, but this Article 199, your lordship uses the word law. Law can include ordinances, rules. It will include the previous Supreme Court rules also, because the previous Supreme Court rules were framed in 1956, and they, under Article 268, continue as existing law. So they were also law, and they continued till they were changed and repealed in 1980 by the present rules. So at that point in time, there was no law which actually limited the power of the
Guidance for making rules.
It could be, but as I said, there may be, on my reading of entry 55, there may be some law which can provide for these practices and procedures within very narrow limits, but subject to the principle that nothing can be done in that law that impinges upon the independence of judiciary, and the Baz Mohammed Kakad case is squarely applicable there. There the power of the Chief Justice to constitute benches was impinged upon and it was struck down.
Mr. Bhandari, this court can revisit its own judgment by larger bench. So is it not equal to the appeal? You are overruling the judgment of 3-member bench by 5-member bench. So it is not sort of appeal.
No, my lord.
And the law, which according to you is a judge law, whether judge law cannot be managed through rules or through enactment of the parliament.
My lord, there are twofold answer to that. My lord, appeal is different because appeal determines rights between the parties themselves. It sort of does away with the concept of res judicata. If there is no appeal, the judgment becomes final, the rights are determined and res judicata applies. If you take the matter into appeal,
So it means that you are against the right of appeal provided to the general public. You say the Supreme Court can exercise that right, but the general public cannot.
No, I'm not saying that. I'm saying your power, your lordship's power to overrule previous precedent will not disturb the rights of the parties. The rights are determined. Your overruling is only on a point of law. You will declare the law, you will overrule the previous judgment. The Doso case was overruled in Asma Jilani, and in Sindh High Court Bar, all the previous validating judgments were overruled.
If this
The rights of the parties are not affected.
If this power is structured, what effect it will have?
Well, because the difference is, once the judgment becomes final, even if the judgment is wrong, and even if it is later overruled in a subsequent case, the rights of the parties become final under the judgment. That's the doctrine of res judicata. What your lordship is alluding to is the doctrine of stare decisis. A larger bench can overrule the law declared by an earlier bench, but it cannot upset the rights that have been determined inter partes. Even the legislature can't do that. Even the legislature cannot undo the judgment, can declare a judgment of the court to be of no effect. The legislature can change the law for the future. It can take away the basis for the judgment. But it cannot simply say this is what they did in the NRO case. In the NRO, they declared certain judgments to be void simpliciter. And that was struck down in Mubashir Hassan's case.
It means by overruling our judgment, we ourselves consider that that judgment was wrong.
Yes.
Therefore, there must be some something to revisit it.
Yes, my lord.
The Parliament said, okay, do it in proper manner through the Act of Parliament.
Well, but that's a question of appeal. Appeal is different. Appeal is that the dispute is between A and B. A and B has rights have been determined in the original proceedings, and then they go up in appeal, and those rights are redetermined by the appellate court. The overruling doesn't take place on that basis. Overruling takes place on the basis that the earlier judgment declared the law incorrectly, and the law is now being rectified. So the rights of the parties, even res judicata applies even if the judgment which determined the rights is wrong.
It will amount to, it will not amount to discrimination. For once, at one time, the Supreme Court says this is wrong. On the other hand, Supreme Court said no, this is right.
My lord, but then that raises the problem of finality of judgments, because we are dealing with a human institution which is the court system. You have to have finality of judgments, finality of cases. Otherwise, why not have a second appeal then? Why not have a third appeal then? There is a problem. My lord, your lordship quoted this in
Mr. Uzair Bandari, I must compliment you on 2 counts.
My lord.
One, your extreme patience and good humor to address very different questions from all sides of the bench. And the second is your thorough being fully prepared in this case. Do you want to add anything? Because our questions will never stop. I must draw a line. If you want to add something.
Yes, my lord, let me allow me to address the question.
It's always a pleasure to hear someone who is articulate. There are cobwebs in our minds as well to clear them up.
My lord.
But then we are taking away. Add something?
My lord, I'll just ask for 10 minutes to address the question of appeal.
Counsel, just one last question.
My lord.
You represent a it's a political party. Maybe tomorrow it is in majority in the parliament. From your arguments, what I have gathered is that you actually do not repose your confidence in the parliament. What you have said is, as I have understood, that this is a very good law, but in future the parliament may make a law which may have effect on the independence of judiciary. There is no fundamental right that the political party is, argued that is enforcing. They say it's a good law, it should happen, but their apprehensions have been expressed against the parliament. So, do you think it's a matter which should have in the first place been taken up under Article 184(3)? Because everyone, and kindly if you can cite any example in any jurisdiction where a good law, a law that actually ensures access to justice, may have been struck down by any court.
Well, Lord, I'll do that. The Indian Supreme Court did that in the Advocate on Records case, 2016, Volume 1, 2016, Volume 1, SCC, Volume 5, SCC, page 1. Their National Judicial Appointment Commission had been reconstituted by the 99th Amendment of the Constitution. They put in experts from the public to help and to sort of advise in the process of appointment of judges. That law was struck down by the Indian Supreme Court. A constitutional amendment was struck down because it violated the independence of judiciary, even though, and this is most critical, and I'll...
Learned Counsel, here in this case, Learned Counsel, here in this case, it is actually promoting and advancing the independence of judiciary.
It is not. My lord, I am not for a moment conceding that this is a good law.
As a political party,
it is not a good law.
This is your stance.
My lord, it is not my stance, and I am not conceding that it is a good law. It is half-baked. it creates more problems than it solves. It's being dressed up as a good law. For example, if your lordship actually decides to turn the autocrat that your lordship just said you were, where is the provision in this act which says that how will the cases be fixed? Section 2 simply says the committee will constitute benches and allocate cases to them. What if your lordship decides that if, despite that allocation, I'm not going to fix any case?
We can
This
frame
act
the
doesn't-
rules.
नहीं,
We
बिल्कुल,
can frame the rules for that.
ये
So, it's
ये
a
देखिए
half-baked
वो
provision.
मेरे
We
दोनों
can
तरफ
frame the
दो फरिश्ते जो बैठे हैं वो मुझ पे नजर रखेंगे, आप फिक्र ना करिए।
नहीं, वो-
इधर और भंडारी साहब
नहीं,
एक कमिटमेंट तो आप फिर कर ही रहे हैं ना आज कि जब आप की पॉलिटिकल पार्टी अगर कल इलेक्शन जीत जाती है तो पहला बिल आप पार्लियामेंट में इसको रिपील करने का डालेंगे ना।
My lord, मैं तो ये कमिटमेंट नहीं दे सकता।
क्यों? अब इतना बुरा कानून है, फौरन रिपील करवा लीजिएगा। हम फिर पुराने उस पे चले जाएंगे। ये आप कमिटमेंट नहीं दे सकते, ये तो अजीब बात है। इतना बुरा कानून है मगर मैं ये कमिटमेंट नहीं दूंगा।
नहीं, हो सकता है इसको कॉन्स्टिट्यूशनली प्रोटेक्ट
हो सकता है शायद आपको सूट करे,
अगर अपील दे दें इसको
तो शायद सूट करे, इसलिए
मतलब मैं
ये देखिए ये बात असूली बातें होती
कल
है
क्या
ना।
होगा जी वो तो मैं नहीं कह सकता, वो तो कोई भी नहीं कह सकता।
चलिए अब एक लेट्स वाइंड इट अप।
मैं सिर्फ इस पे सर ये जो मैं आपको माय लॉर्ड द जजमेंट आई रेफर्ड in para 990 of that judgment there is very detailed discussion on how the collegium system in India has totally destroyed matters. There your lordship know in India the power of appointing and recommending judges for appointment does not vest in the chief justice, it vests in the collegium of 5 judges. And this para 990 at page 689 deals with the problems that the collegium system caused. And that goes on and on. Favoritism, nepotism, abuse of power. But they nonetheless said,
Judicial
we are
Commission
not
of
letting the
Pakistan,
parliament
Judicial
interfere
Commission
now.
and Parliamentary Committee भी तो कॉलेजियम ही चल रहा है ना, तो वो
Exactly.
against the independence of judiciary नहीं है Parliamentary Committee।
नहीं वो और कर रहा हूँ मैं ये कह रहा हूँ जो माय लॉर्ड ने सवाल पूछा था कि इधर
Learned counsel
इंडियन सुप्रीम कोर्ट
in-
ने एक्सेप्ट किया कि बहुत प्रॉब्लम्स हैं कोलिजियम सिस्टम में, हम बाहर वाले को फिक्स नहीं करने देंगे। माय लॉर्ड विद रिस्पेक्ट, अगर आप अपने प्रॉब्लम्स जो आपकी जुरिस्डिक्शन में है वो बाहर वालों को सॉल्व कर देंगे, फॉर मी दैट ब्रिंग्स बैक सेलस पॉपुलर सुप्रीमा लेक्स डॉक्ट्रिन ऑफ नेसेसिटी। हर मार्शल लॉ भी इसी बेसिस पे लगा
सुप्रीम कोर्ट के 3 जजेस हैं,
चीफ
चीफ जस्टिस एंड 2
मार्शल लॉ
जजेस,
लगा देते हैं,
चीफ
Martial law भी तो
जस्टिस
इसी
एंड
पे
2
लगे।
सीनियर जजेस इन द कॉलेजियम, तो ये बाहर वाला कौन है यहाँ पे?
इधर सर
यहाँ पे अगर कमेटी है तो बाहर से कौन आ रहा है?
सर मैं और बात कर रहा हूँ।
नहीं,
कहेगा कॉलेजियम सिस्टम
मैं तो-
अच्छा नहीं होता,
ये
मैं तो-
बताइए,
मैं तो-
उसमें नुकसान होता है।
as a political party, do you support the powers vested in the Chief Justice
No.
and not in 3 judges?
No, I'm saying it should be maybe more than 3 judges.
No,
that's-
Learned Counsel,
I
more
am
than
not in
Learned.
favor, I'm not saying that the
No,
Chief
Learned
Justice
Counsel,
should
you
be
have to be very clear.
Bhandari Sahab,
Do you support the
170
previous system where the Chief Justice had absolute discretion?
I don't support that.
So it's a good law.
It is not.
Secondly,
It is not. Malab, I don't concede it's a good law.
Bhandari Sahab.
Because from this extreme, you don't necessarily go to that extreme. You go step by
Learned
step.
Counsel, that
Bhandari
is,
Sahab.
you are questioning the wisdom of the parliament as a political party.
The question
Tomorrow,
here is
your
the
client
process.
would be in the
Malab,
parliament.
if tomorrow they do take my advice before enacting law, I will advise them to enact a better law than this. This for me is not a good law.
भंडारी साहब, जो कॉन्स्टिट्यूशन में सुप्रीम कोर्ट की डेफिनेशन है उसमें चीफ जस्टिस एंड जजेस,
सब जजेस
जो चीफ जस्टिस के पास इख्तियारात हैं 191 में कि वो कुछ एडमिनिस्ट्रेटिव काम अपने जजेस को देते हैं, लेकिन अगर यहाँ पे अंडर द लॉ कुछ इनको ये अथॉरिटी मिल जाती है तो जो कॉन्सेप्ट ऑफ इक्वलिटी है अमंग्स द जजेस अपार्ट फ्रॉम द चीफ जस्टिस वो कॉम्प्रोमाइज नहीं होगी।
बाज मोहम्मद काकड़ केस में एग्जैक्टली यही हुआ था कि स्टैट्यूट के थ्रू चीफ जस्टिस की कॉन्स्टिट्यूशनल पावर्स को चेंज करने की कोशिश की गई और उन्होंने कहा नहीं हो सकता। मेरी तो सबमिशन ये है, मैं बिल्कुल एक मुतलकुल ऐलान चीफ जस्टिस के हक में नहीं हूं।
भंडारी, चीफ जस्टिस के पावर कहीं डिफाइंड है कॉन्स्टिट्यूशन?
कई जगह है, फॉर
एक जगह बता दे।
नहीं वो सर जैसे 140s में कि चीफ जस्टिस आर्बिट्रेटर्स अपॉइंट कर सकते हैं।
As far as the working of the Supreme Court and the constitution of the benches,
The subject matter of this act, my lord is asking, yes, of course, the Chief Justice powers are mentioned in various provisions. Regarding the subject matter of this case, Is there anything which
No,
can be
not
utilized?
except the constitutional
191
convention, that appointment
191
of,
में
that constitution of benches is your prerogative.
You see, 191 में इसीलिए रूल मेकिंग पावर दी है कि ये कॉन्स्टिट्यूशन ऑफ बेंचेस, डिस्ट्रीब्यूशन ऑफ वर्क, कमिटीज, रिव्यू, रिविजन्स, व्हाटएवर, उसके जो रूल्स हैं वो सुप्रीम कोर्ट खुद बनाए. एंड अ फुल कोर्ट इन 1980 डिड मेक दोज रूल्स, और उससे पहले भी रूल्स बने थे जो आई मीन विच फॉलोड द कॉन्स्टिट्यूशनल कमांड. तो वो कॉन्स्टिट्यूशन में तो ये सारी चीजें नहीं लिखी जा सकती, इसीलिए रूल मेकिंग पावर दी गई. सो लेट्स मूव ऑन टू द अपील बिट.
My lord, the appeal and I.
सर फैसला कर दिया.
My lord, there is one direct precedent which deals with the question of appeal and such similar matters, which is Sabir Shah's case. PLD 1995 Supreme Court
एंड प्रोसीजर एक्ट
66.
पर सुप्रीम कोर्ट की समाअत जारी है. चीफ जस्टिस काजी फाइज ईसा की सरबराही में समाअत जारी है. चीफ जस्टिस की जानिब से ये कहा गया है कि इस कानून का असर चीफ जस्टिस और सीनियर